In 1933, the federal government ordered every American to surrender their gold. Not stolen gold, not counterfeit gold, their own gold, the coins in household safes, the bars stored under floorboards, the private savings people had protected through every banking collapse of the decade before. Executive Order 6102 gave citizens until May 1st to deliver it to the Federal Reserve at a government-fixed price. Anyone who refused faced a $10,000 fine and 10 years in federal prison. After the government collected the last ounce, it quietly raised the official price of gold by nearly 70%. The people who complied took the loss. The Federal Reserve took the profit. That is number 14 on this list. Number 7 involved a tax loophole so effective that Congress rewrote an entire section of the Internal Revenue Code specifically to contain it, and investors used it to build generational real estate wealth without paying a dollar in capital gains for 30 years. And number 1 is the story of a legal advantage so massive that the government fought 26 years to close it, lost in court the first time, and kept coming back until it finally won. These are 20 moments when ordinary Americans found a way to earn more, save more, or keep more of what they had built, and every single one ended with someone in Washington deciding it had gone far enough. Hit subscribe, because this is the part of American financial history they never put in the curriculum. So, let me ask you something. Think about the last time you followed a rule without stopping to ask who wrote it, the permit fee you paid, the license you applied for, the tax you sent without reading the line item. Most regulations exist for legitimate reasons, but some of them, and this list proves it, exist because someone with a lobbyist decided your income was their competition. Every item here started as something Americans did naturally, legally, and profitably. Then someone in power decided it needed to stop. Ask yourself who benefited from that decision. The answer explains everything. Number 20, selling homemade baked goods. Before cottage food laws existed, selling a loaf of banana bread to a neighbor could generate a fine from the county health department. Home kitchens were classified the same as unlicensed commercial restaurants. Grandmothers who had sold pies at church fundraisers for 30 years found themselves in violation of food safety codes written for industrial processors. A woman in Wisconsin was shut down in 2011 for selling homemade cookies to people who had specifically sought them out. The resulting national backlash forced the state legislature to pass a cottage food bill within 2 years. By 2024, nearly every state had followed. The fight took years of ordinary bakers pushing back against a system that treated a kitchen table as a public health crisis. The government did not move against home baking because it was dangerous. It moved because it was unregulated. And in American commerce, unregulated income is the category that keeps bureaucrats awake at night. Number 19, backyard chickens. In the early 2000s, cities across the country were fining homeowners for keeping egg-laying hens in residential backyards, not roosters. Quiet hens saving families $50 a month in grocery costs. Zoning boards classified them as livestock and banned them from residential areas, sometimes under neighborhood pressure, sometimes under quiet influence from commercial egg producers who saw backyard flocks as competition they could not price match. In Cleveland, a man went to court in 2009 over 4 hens in a coop he had built himself. The city spent more prosecuting the case than those birds would produce in eggs over their entire lives. The urban farming movement pushed back hard, and by 2020, over 80% of the largest American cities allowed some form of backyard poultry. The eggs were fresher, the cost was lower, and the government spent a decade trying to stop something your great-grandmother would have called a Tuesday. Number 18, roadside produce stands. Selling tomatoes from a folding table on a county road is as old as the country itself. By the 1990s, health departments and zoning boards had converted it into a paperwork exercise requiring permits, inspections, and commercial licenses. A farmer in Virginia was fined $5,000 in 2014 for selling produce without a retail license, vegetables picked from his own land that morning. The regulations were written to protect consumers from contaminated commercial supply chains. In practice, they protected grocery chains from farmers who sold direct, and kept the full retail margin instead of the wholesale fraction distributors offered. State legislatures eventually rolled back the worst of it after farm advocacy groups made enough persistent noise. But for decades, the simplest transaction in American commerce, a farmer selling what he grew, required government permission to complete. Number 17. Hair braiding without a cosmetology license. Through the 1990s and 2000s, African American women across the South were fined and shut down for braiding hair without state-issued cosmetology licenses. Those licenses required up to 2,100 hours of training and thousands of dollars in tuition, covering chemical treatments and nail procedures that had no connection to braiding. A woman in Mississippi who had braided hair since childhood was told she needed 1,500 hours of formal schooling before she could legally charge $10 for cornrows. The Institute for Justice filed suits across multiple states. By 2023, more than 20 states had passed exemptions for natural hair braiding, but the damage ran deep. Thousands of women, predominantly Black and lower income, had been excluded from honest work for years by licensing boards that existed to limit competition rather than protect anyone from anything. Number 16. Jitney cabs. Before Uber, before Lyft, before any of the vocabulary we use to describe the gig economy, there were jitneys. In 1914, car owners in Los Angeles and other cities began offering rides for a nickel, running informal routes that undercut streetcar fares while offering door-to-door flexibility the fixed rail lines could not match. Within months, more than 60,000 jitneys were operating across American cities. The streetcar companies drafted ordinances. By 1918, most cities had passed permit requirements, insurance mandates, and route restrictions that made jitney driving economically impossible. The streetcar monopoly survived. The most flexible urban transportation system America had ever produced disappeared for a century. When ride-sharing returned after 2010, the taxi industry ran the identical playbook. The parallel was not coincidence. It was institutional memory. The government did not ban jitneys because they were unsafe. It banned them because a well-funded competitor demanded it. Number 15. Penny auctions. When banks moved to foreclose on family farms in the early 1930s, neighbors showed up to the auction and made certain nobody bid above a penny. A farm appraised at $5,000 would sell for 35 cents. The neighbors returned the deed to the original family. Banks were furious. Judges threatened contempt charges. In Iowa in 1933, a group of farmers removed a judge from his bench after he refused to halt a foreclosure sale. The state legislature passed a moratorium on farm foreclosures within weeks. What looked from outside like a mob was something more specific: organized community resistance to a banking system that had broken a compact with rural America. The penny auction did not just save individual farms. It pressured state and federal governments to acknowledge the depth of that failure. The government tried to stop it because it embarrassed the banks. The people kept doing it because there was nowhere else to turn. Number 14. Private gold ownership. On April 5, 1933, President Roosevelt signed Executive Order 6102. American citizens were given until May 1st to surrender all gold coins, bullion, and certificates to the Federal Reserve at the fixed price of $20.67 per ounce. Failure to comply carried a $10,000 fine and 10 years in federal prison. After collection was complete, the government revalued gold to $35 per ounce, a 69% increase overnight. Every citizen who had surrendered their holdings at the government price had immediately lost that difference in purchasing power. The stated rationale was economic stabilization during the Depression. The practical consequence was the largest forced transfer of private wealth in American history. The ban held for over 40 years. Gerald Ford signed the repeal in 1974. By then, gold was trading at $195 per ounce. The arithmetic of what the original holders lost does not require any elaboration. If you are still watching, hit subscribe right now and drop a like on this video. It helps more people find this information. The second half of this list is where things get complicated. Number 13. Selling raw milk. For generations, Americans bought milk directly from the farms that produced it. As pasteurization became the commercial standard, the FDA classified raw milk as a public health hazard and made its interstate sale illegal. Direct farm-to-consumer sales were restricted or outright banned in most states by the 1980s, even between consenting adults who understood exactly what they were purchasing. In 2011, an Amish farmer in Pennsylvania had his operation raided at dawn by federal agents for selling raw milk across state lines. The case generated national headlines and became a focal point for food freedom advocates who argued the enforcement had nothing to do with safety and everything to do with control of the supply chain. Both sides have documented evidence, but armed early morning raids on Amish farms represent a notable escalation for a disagreement about dairy. Number 12. Home distilling. George Washington operated one of the largest whiskey distilleries in the country at Mount Vernon. Since Prohibition, distilling spirits at home has been a federal felony, carrying up to 10 years in prison and a $10,000 fine, even for personal use and even in quantities too small to share. Home brewing beer is legal. Home winemaking is legal. The still is where the federal government draws the line, and the reason is excise tax. The federal levy on distilled spirits generates billions in annual revenue. A gallon made in your own kitchen is a gallon the government cannot tax. New Zealand legalized home distilling in 1996 with no measurable public safety consequences. The United States has not followed because the liquor lobby and the tax code are pointing in the same direction. The prohibition has nothing to do with what you pour into your own glass. It has everything to do with what the Treasury cannot collect from it. Number 11. Unlicensed lemonade stands. Children operating lemonade stands have been shut down by health inspectors and police in at least a dozen states. In 2011, a county health official in Georgia closed a stand run by 3 girls between the ages of 10 and 14 because they lacked a business license and a food service permit. The daily fine was $50. In Texas, state troopers shut down 2 sisters selling cups to raise money for a Father's Day gift. The public response was immediate and disproportionately furious, which tells you something about how deep the frustration with regulatory overreach had run. Country Time Lemonade launched a legal defense fund for children cited for selling lemonade. Several states passed laws specifically protecting juvenile lemonade stands from permit requirements. The fact that those laws had to be written at all is the data point worth sitting with. Number 10. Collecting rainwater. In Western states governed by prior appropriation water law, capturing rain that fell on your own property was illegal. Colorado, Utah, and Oregon all maintain statutes classifying rainwater as a public resource belonging to downstream rights holders. A man in Oregon was sentenced to 30 days in jail in 2012 for storing water in 3 reservoirs on land he owned outright, on the grounds that the water belonged to a downstream watershed. Colorado legalized residential rain barrels in 2016, a maximum of 110 gallons. Utah followed with similar limits. The underlying legal framework still treats precipitation as state property in some jurisdictions. In an era when household water bills climb every year, the right to collect free water from your own gutter remains one of the stranger legal disputes in American civic life. Number 9. Growing hemp. Hemp and marijuana come from the same plant family, but serve entirely different purposes and contain different compounds. Hemp has been used for rope, textiles, paper, and construction materials for centuries. It contains almost no psychoactive THC. When Congress passed the Marijuana Tax Act of 1937, hemp was swept into the prohibition by proximity. For the next 80 years, American farmers were barred from growing one of the most versatile crops on earth, while the country imported tens of thousands of tons annually from Canada and China. The 2018 Farm Bill finally legalized industrial hemp. Within 4 years, the American hemp industry exceeded $800 million in annual revenue. 80 years of prohibition did not reduce demand for hemp. It redirected the money to foreign producers and kept American farmers from a crop their own ancestors had grown since the colonial period. Number 8. Tax-free bartering. Through the 1970s, barter networks spread rapidly among small business owners. A dentist treated a plumber's family. The plumber repiped the dentist's office. No money changed hands. No taxes were filed. The IRS watched the growth carefully. The Tax Equity and Fiscal Responsibility Act of 1982 required formal barter exchanges to report all transactions and treat the fair market value of goods and services received as taxable income. Trading your labor for someone else's meant both parties owed income tax on the exchange value, even though neither had touched a dollar. The law did not ban bartering. It made organized barter networks complicated enough that most of them collapsed. Informal arrangements continued without paper trails. The government could not stop people from helping each other. It could only mandate that they report it. Number 7. The 1031 Exchange. Section 1031 of the Internal Revenue Code allowed property investors to sell one asset and roll the proceeds into another of like kind without triggering capital gains tax, provided specific reinvestment timelines were followed. Patient investors chained these exchanges for decades, deferring gains indefinitely and building portfolios worth millions without settling a single capital gains bill. The IRS flagged the strategy repeatedly. Congressional hearings examined it from multiple directions. The Tax Cuts and Jobs Act of 2017 finally restricted 1031 exchanges to real property, eliminating the provision for personal property, vehicles, and equipment. Real estate exchanges survived intact. Investors who mastered the mechanism before the restriction made it narrower have deferred tax obligations that may never come due in their lifetimes. The government did not curtail 1031 because it was illegal. It narrowed it because it worked exactly as intended for people who were not supposed to benefit that much. Number 6. Food trucks. The modern food truck industry nearly died before it started. In the early 2000s, cities across America classified food trucks as nuisances and confined them to industrial zones, away from every commercial street where customers actually walked. Chicago prohibited food trucks from operating within 200 feet of any restaurant, which eliminated every viable location in the city. The restaurant lobby framed it as a tax fairness issue. Food trucks paid no property tax and no commercial lease. The real argument was simpler. Food trucks offered better food at lower prices because their overhead was a fraction of a brick-and-mortar operation. Court challenges accumulated. The Institute for Justice filed suits in multiple cities on economic liberty grounds. By 2020, most major cities had loosened restrictions, and the industry had crossed $1 billion in annual revenue. For the decade before that, city governments tried to protect established restaurants from entrepreneurs who could not afford a storefront but could afford a grill. Number 5. Selling electricity back to the grid. When early solar adopters tried to sell surplus power to utility companies in the 1990s, the utilities refused. Some cited grid safety concerns. Others simply declined to install meters capable of measuring reverse flow. The actual issue was the same in every state. Each kilowatt a homeowner generated was a kilowatt the utility could not sell at full retail margin. Net metering laws, which required utilities to purchase excess solar production at retail rates, were contested in state legislatures and regulatory commissions for years. Most states eventually adopted some version. Then utilities in Nevada, Florida, and Alabama successfully lobbied to reduce or eliminate net metering credits, clawing back the savings that had made rooftop solar financially viable for ordinary households. The fight has not ended. Power companies want to be the only seller of electricity. Homeowners want the sun hitting their own roof to be worth something. The government answer in any given state depends on who wrote the larger check to the relevant campaign fund. Number 4. Short-term rentals. When Airbnb launched in 2008, it converted spare bedrooms into income sources for millions of homeowners who had previously earned nothing from those rooms. By 2015, hosts in major cities were clearing thousands of dollars monthly. Hotel occupancy declined. City councils responded with registration requirements, permit fees, hotel taxes, fines, and outright bans. New York made it illegal to rent a full apartment for fewer than 30 days without the host present. San Francisco required registration, hotel tax remittance, and liability insurance. Fines reached $7,500 per violation. The hotel industry financed a significant portion of the lobbying that produced these restrictions. Some regulations addressed real problems. Investor-owned buildings converted entirely to short-term rentals did hollow out residential housing markets in some neighborhoods. But the speed and severity of the response made the underlying motive visible. When ordinary people discovered a way to earn money from assets they already owned, the industry that charged more for less demanded the government step in. Number 3. Cryptocurrency. In 2013, the IRS had no formal position on Bitcoin. People mined it in home setups, traded it on unregulated platforms, and accumulated gains that existed in no government database anywhere. The agency issued initial guidance in 2014, but enforcement was minimal for years. As values climbed into the tens of thousands per coin, the stakes became impossible to overlook. The IRS sent warning letters to over 10,000 taxpayers in 2019. The 2021 infrastructure bill required crypto brokers to report transactions the same way traditional brokerages report securities trades. Every regulatory proposal since has pointed in the same direction, reducing the invisibility of digital asset movement. The government did not pursue cryptocurrency because it was inherently dangerous. It pursued it because money moving outside observable channels is money the Treasury cannot account for, and the Treasury does not accept that arrangement indefinitely. Every new reporting requirement is the same argument written in different language. Number 2. The home office deduction. For years, Americans who worked from home could deduct a proportional share of mortgage costs, utilities, and insurance as a business expense. A dedicated workspace occupying 15% of a home's floor area reduced taxable income by 15% of housing costs. The IRS audited home office claims at elevated rates for decades, treating the deduction as a red flag rather than a legitimate cost of doing business. A 1993 Supreme Court ruling narrowed eligibility significantly. Congress restored broader access in 1999. Then the Tax Cuts and Jobs Act of 2017 eliminated the deduction entirely for employees, preserving it only for the self-employed. Millions of Americans who had been legally reducing their tax liability lost the benefit in a single legislative session. The deduction was not eliminated because people were abusing it. It was eliminated because it cost the Treasury more than the Treasury was prepared to return. Number 1. Selling online without collecting sales tax. The 1992 Supreme Court ruling in Quill Corporation versus North Dakota established that states could not compel a business to collect sales tax unless that business maintained a physical presence within the state. Online retail did not yet exist as a category when the case was decided. When it became one, the ruling created the most consequential pricing advantage in the history of American commerce. An online seller with no warehouse in your state could legally undercut every local retailer by the full amount of your state's sales tax, between 5 and 10% depending on where you lived. Amazon built its early logistics strategy around minimizing the number of states where it had nexus. Small sellers collected nothing and kept the difference. Consumers saved billions annually. State governments estimated combined losses exceeding $23 billion in uncollected revenue per year and spent more than 2 decades filing legislative challenges, regulatory proposals, and legal arguments trying to close the gap. In 2018, the Supreme Court ruled in South Dakota versus Wayfair and overturned Quill. States gained the authority to require tax collection regardless of physical presence, and the online pricing advantage ended overnight. The government fought 26 years, lost in court the first time, and eventually won because the money involved had grown too large to leave alone. Every item on this list followed the same arc. Someone found a way to earn more, keep more, or build more outside the channels the established system had set up. The system noticed, rules were written, permits were required, raids were organized, and courts were mobilized. Some of those responses protected genuine public interests. Many of them protected someone's revenue. The honest reaction to that pattern is not cynicism. It is awareness. Know what is legal, know why the rules exist, and know who benefits most from keeping them exactly where they are. Drop the number that surprised you most in the comments. Then tell me what you think is on the next list. because the things the government is currently watching do not end here. Subscribe if you haven't already, like this video, and I'll see you in the next one.